Wow, this is going to take a little bit of time, so get your popcorn and something to drink, coffee. This is my cistern, so it's water. But get something, get comfortable. The new purchase contract goes into effect September the 1st. And there are some great changes. Some of it you're going to be excited about. And then there are those you're not going to be excited about. All right, so let's go to the share screen and let me get this pulled up for all of us to see. I will be emailing you a copy of this, the highlighted version, so that you get an idea of, can more easily look through these things. But all right, change number one to pay attention to is right on line number 6. Let's start it off from the beginning. This is a change from what had been. It used to be like inspections where time is of the essence. Now everything is time is of the essence. All timelines and deadlines under the contract shall be strictly construed. Time is of the essence with regard to any and all timelines. Now, rather interesting that they said that, because a little bit later on, it's going to talk about if there is something where due diligence is being done and there's a delay in the closing, that the delay can be extended for up to 7 days. So it's time is of the essence with one exception. So everything, inspection timelines, response timelines, financing timeline, everything is time is of the essence. What does that mean? Get yourself a sheet that has a breakdown of every time consideration within a purchase contract. Make it into a checklist, keep it with every folder, and then that way when you're going through, it's very easy on one sheet to say, oh, okay, what's the next timeline, next due date on anything in a particular transaction, because everything is now time is of the essence. All right, scrolling on down, the big change. There's a couple other big change, but one of the big changes is dealing with earnest money. The earnest money has been divided into two main categories. Category one, if a brokerage is holding it, same basic idea. Let me see. I did not, you've been listening to me from a distance because I didn't pull out my mic. So I've got my mic now. Bear with the bald guy. All right. All right. We're set up. With the earnest money, basically everything's the same, dealing with when a brokerage is holding the earnest money. What is different is there is a growing number of smart real estate companies that are allowing the title companies to hold earnest money. The laws governing how a brokerage handles earnest money does not apply to anything that is not a brokerage. So if a title company is holding earnest money, there's no state guidelines for how that title company is going to hold, disperse, whatever the the earnest money. So what this means is we have been working on getting title companies to agree to handling the disbursement of the earnest money in accordance with state guidelines, whether it's Kentucky's or it's Ohio's. And we've been sending out to the title companies that our agents have mentioned they like working with to get them on board with this. What does that look like? Let me show you what the exact verbiage is. All right, for Kentucky, if you see right here, boop. All right, earnest money shall be held by title company name of buyer's choice. Earnest money shall be dispersed by whatever the title company name is, pursuant to the terms contained in this contract in Kentucky Revised Statute 324.111. And then the same idea, same wording for the Ohio title companies, with the exception it's Ohio Revised Codes instead of Kentucky Revised Statutes. So, and title companies that have agreed to this, I'm going to have a list going up across the screen of what we have so far. The thing is, if you have a title company you want to do business with that has not signed up on board with this verbiage, you need to reach out to them. Let me reach out to them or something. I need to have an email confirming they are in agreement to those words. This is important only simply because third-party companies, non-brokerages, are not bound by any laws, requirements, or anything else in handling the earnest money. So this is something we're going to be seeing. I expect to see this eventually pop up in Northern Kentucky and Lexington's contracts, and then across the state of Ohio as well, because this has been a repeated drumbeat. In conversation with the Kentucky Association of Realtors legal department, they are very concerned about this. So it is a change. It's an additional thing to do, and as such is not necessarily a fun thing, but it is a necessary thing to protect our clients. So if you've got a title company that is not scrolling across the screen that you prefer using, please let me know ASAP so that we can get this shot to them. There's one title company that in response to this sent me a 3 to 5 page addendum that is a real work. So some title companies are on board, some are not. We've got to make sure everyone's singing off the same page. All right, let's keep on scrolling down here. That's all that's of significance on page 1. Page 2, in the financing, important change. Buyer shall provide written notification to seller naming selected lender and confirming that this provision, i.e. the formal application or intent to proceed, is been satisfied. So this is something, again, be aware. This is one of those little things. Make your checklist, timeline checklist. Make sure this is one of those things in there. And then in addition to this, we have buyer or buyer's lender shall provide written notification to seller of the loan approval. That's clear to close. That's different. This is in addition. It used to be just conditional approval. See where the little flasher is? Now is added clear to close. So clear to close is now part of our little timing checklist. Appraisal contingency. Buyer shall have the option to terminate this contract by delivering written notice to seller, 1, in event of the purchase price via cash or underfunding source within X number of calendar days. So, you know, that's a little bit of a change from it was with, in connection with the, conditional approval. All right, so inclusion. This is a big change. Note, pay attention, catch this. Just, you know, what can you say? All affixed items. I like to say anything nailed, glued, or screwed to the property. All right, so the following items, if they are now located, connected with electrical, heating, air, including window units, air conditioning, bathroom mirrors, that's actually a repeat, shades, blinds, awnings, window rods. So curtain rods, this is a repeat, this isn't new, but curtain rods are attached. The curtains hanging on them are personal property items. Rods are attached to the property and are part of the real estate. Free hanging curtains are not. However, if that curtain is attached to a board that is attached to the wall, those curtains are considered an attachment. Television and or sound system mounting bracket, excluding televisions or sound system. All right, that has been an ongoing debate, but you know, this helps to clarify that a little bit more. Here's the big whopper. All right, the following appliances shall also be included: ranges, ovens, microwaves, refrigerator, dishwasher, garbage disposals. You know, I like to see someone rip the sink out to get the garbage disposal out. And here it says garbage disposers, not disposals. Trash compactors, not for notwithstanding the foregoing any freestanding countertop appliances, i.e. microwaves. So, but it's interesting. These things have been added in here. This is in my boo list. Guys, gals, pay attention to this. One of the concerns is if there's a nice shiny side-by-side stainless steel refrigerator in the kitchen and an Autumn Harvest gold clunker refrigerator in the garage, be sure your contract stipulates the appliances in the kitchen on the date of showing of, and then include the date. There have been occurrences where it just says refrigerator. It doesn't say which one, that the seller took the nice shiny new one and put the hot autumn gold one, the clunker, in the kitchen. They're following contract guidelines. So just be aware, make sure those things are specific, because now it is not a check. It is not written in. It is in the contract that these items stay. If your buyer does not want those items to stay, make sure they're crossed out and initialed. If your seller does not want those items to stay, make sure they get crossed out and initialed. This is an addition. It is a change. It is one I would have done differently. But I wasn't there to share my thoughts, and they didn't call and ask. Going on down, seller certification is broken into different categories all the way down. Used to be more in a solid paragraph. So, subject to agreement pertaining to joint maintenance of shared aspects of the real estate not covered by HOA, like a shared driveway or a party wall or something to that extent. Are we having fun yet? So then homeowner association, and just this is a side note, this is not something that's new, but helps to clarify a little bit, separate from HOA fees, for currently approved or pending homeowner association assessment. And again, what is typical HOA fees and what is in addition to it? Documents, bottom of the page, documents recorded at the county. The association declaration, the association financial statements, rules and regulation, schedule of monthly, annual, and special assessment fees, architectural standards, the bylaws and articles of incorporation, the minutes for the previous count them, 2 years, and pertinent and other pertinent documents. Sellers got to get those suckers ready before you get the buyer in place, because it's usually a short fuse from the contract to when those documents are needed. If seller, note down here on 175, if seller fails to provide documents as required, buyer has the right to terminate this contract within 3 days of the document delivery period. So again, if you're listing agent, get on those HOA documents ahead of the game. And as we scroll on down to the very bottom of the page, as far as inspection contingencies, this is continuing on. Ohio licensed home inspectors and other professionals qualified to perform services. Now it is official that the inspector has to be licensed in the state of Ohio. But the thing that it caught my eye, and this is, it's left a little bit of a squeegee door open. Buyers has the option to have the real estate inspected by who? Uncle Bob? Maybe not. By Ohio licensed home inspectors and or other professionals qualified to perform assessments and services in a specific area of expertise. Intent on that is like HVAC, structural engineers, things to that extent. But it leaves the door open that maybe Uncle Bob can do the inspection for Junior in buying the house. So it makes it less of an open door for the buyer to bring in whoever. And that might be a way, if you're working with a buyer and you don't have a whole lot of confidence that Uncle Bob knows the difference between a can of paint and a can of spray paint. This could be something to bring up to the buyer, saying, hey, use who you want, but this contract is focused on professionals doing the inspection. Buyer shall be responsible for any damage done by the inspector. So it's buyer's responsibility, and agrees that, I like this, buyer understands and agrees that the inspection reports are not to be considered a list of required repairs and or corrections to the real estate. Talking with your buyer up front before the inspection, make sure you bring up every house has issues. You're not buying a perfect house. There is no such thing as a perfect house. The purpose of the inspection is for major considerations. Is it safe, sound, secure? You don't want the house falling down around your ears, burning up, or getting waterlogged. So, help them to understand the distinction between those two. Going on down, inspection. Oh, guys. The time frame's been goobered up tremendously. All right, so hang with me on this. We now have 3 inspection timelines, not 2. What used to be was the inspection time frame where the inspection needed to be done and report or addendum, post-inspection addendum, submitted to the seller in that time frame. And then that started the settlement period. Take the settlement period, slide it over a notch, and insert consideration period. All right, let's get into this. All right, buyer shall have a time period, otherwise known as inspection period. Prior to the end of that period, there should be a defect notice. We call it the post-inspection addendum. The defect shall identify conditions to which the buyer is requesting correction by seller and will include relevant portions of the inspection report. That's really no different. Buyer agrees, we come back to what I just said, that minor routine maintenance and cosmetic items are not to be considered material, and the buyer may not object to those in the defect notice. Got to get my emphasis on the right syllable. All right, so here's an addition. I didn't highlight this. Highlight this. All right, there's 2 check boxes, and it's an or. All right, with the defect notice, the buyer shall, together with the defect notice, buyer shall provide seller of written estimates for completion of requested corrections. So with that option, you need to add time to the inspection period, because not only is it the inspection period, but before you submit the defect notice, you have to have written bids by contractors to address whatever those defects are in the home inspection. So now instead of 5 to 7 days for an inspection period, you're probably pushing it out to 15 days to allow those individual contractors to come in. Or, are we ready for an or? Checkbox. Seller shall obtain written estimates during the consideration period. There it is, the consideration period. That's where the seller goes and gets their own contractors to consider how they are going to respond to the buyer. All right. In the event buyer has timely delivered to seller a defect notice, seller shall have a period of up to blank calendar days, the consideration period, beginning the day following the delivery of the defect notice to evaluate the buyer's request for corrections. Okay, so we now have inspection period, consideration period, and then settlement period. Consideration period is predominantly to allow the seller to research what it's going to take to address these concerns that the buyer brought up and what they are going to do with it. So prior to the end of the consideration period, provide a buyer signed written agreement to correct everything, or counter offer, going back and forth. And then delivery of either notice in section 11 or 14B shall be considered the end of the consideration period. And then remember that timeline checklist I told you about? In the event that the seller shall fail to timely provide any required written notice to buyer, seller shall be deemed to have agreed to the correct of the defects in the manner detailed and requested in the defect notice. In the event seller has counter offered on that, it begins the 3rd time period, and that is the settlement period, and that's where the negotiating goes back and forth. So instead of just extending the settlement period to allow the seller to research these things, we now have a consideration period. Inspection period, consideration period in which the seller is looking at options, and then when the seller responds with a counter to the defect addendum, that begins the settlement period. In the event that the parties fail to reach a mutually signed written agreement under this section, this contract shall be automatically terminated. All right, important, again, timeline checklist, and we can work on this, and we can just create our own if we want to, and we can share it with the group, which would be a very good idea. If you see that the timeline is getting very, very tight in either the inspection period, the consideration period or the settlement period, write the bloomin' extension for the thing, because otherwise the contract is automatically terminated once that timeline has gone past. This is the part, it's a nice addition. It keeps the buyer from backing out, using the inspection period to back out of the contract. That's now gone bye-bye. All right. In the event that the buyer's inspections reveal conditions, which conditions were, what do we say, not disclosed by the seller prior to the contract, and that evidence of one or more of the following specific matters: conditions adversely affecting structural integrity, presence of asbestos, lead-based paint, and or other hazardous materials, and or blank. And then that situation, the buyer can cancel or terminate the contract unilaterally. You know, if they do that, they have to provide relevant portion of buyer's inspection reports evidencing the existence of such condition. All right, so that is a change. Be aware of that. The buyer can no longer use the inspection as a get out of jail card free get out of jail. Get out of jail free card, whatever it is, play Monopoly. So there's limited reasons why a buyer can just unilaterally back out based on the inspection, and that's in paragraph D in these lines. Buyer is dealing with property insurance verification contingency. Buyer shall have what? What's the date? 14 days. We now have a time limit on this, beginning the day following contract acceptance, to confirm that such insurance policies are available and the cost is acceptable to buyer and buyer's lender. Again, checklist, timeline. This is important. The buyer has 14 days to confirm that insurance is achievable on the property and is in a price range acceptable on the property. All right. Here's another change dealing predominantly with inspections. Buyer acknowledges that buyer is authorized to be, is not, excuse me, little three-letter word, is not authorized to be present on real estate without a licensed real estate agent unless prior express written authorization is obtained from the seller. What does that mean? If you're not there for the home inspection, you have to get permission from the seller for the buyer to be there with the inspector. I like the concept behind this. However, the practice behind it, the listing agreement, it has those initials for the seller to say, yeah, I understand the buyer might be here with the inspector without the agent. However, you as the buyer agent, if you're in that position, you don't know that. You've got to get written permission from the listing agent for the buyer to be there with the inspector without you being there with them. This is an interesting, nice little addition here saying that mortgage lenders' title insurance does not cover the buyer. It gives you a chance to be able to have that discussion with the buyer about title insurance, but otherwise the provisions, the buyer is going to get it. The buyer is asking seller to contribute $300 or asking the seller to pay the whole shebang. That's remained the same. All right. Actually, that's the end of notes on page 7. Look through. Here's something dealing with new construction. It's an expansion of what we currently have in the purchase contract now. Conveyance and closing. Title company name and number. Oh, and number. That's a novel idea. Title company and its attorneys do not represent either buyer or seller. Now, in the real estate industry, we typically consider the title company representing whoever chose them. In reality, they represent the mortgage company, neither of the clients, the buyer or the seller. If buyer or seller desires legal representation, they need to go fetch their own attorney. All right. And then down here, line 420, date of closing shall be, and this is the time is of the essence on every date of this contract. Oh, by the way, there's an exception. Notwithstanding anything to the contrary, in the event the buyer and seller are proceeding in good faith performance under this contract and closing cannot occur due to an occurrence of circumstances out of the direct control of either party, date of closing shall be extended for a period of up to 7 days unless otherwise agreed. So this is the only one that I've come across in this contract where there is a hiccup, an exception to time is of the essence. And then possession and occupancy is a little bit better spelled out. Side note, always, 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 my encouragement is, unless there's an extenuating circumstance, occupancy at closing, all right? If a date and time is put in for occupancy, you have to be sure to go back and change that if anything happens to, well, they actually included that occupancy by the equal number of days closing was extended. But it just makes life so much easier unless there's a solid reason for it. Otherwise, always choose at closing for the date of occupancy. And until such time, seller shall have the right of possession and occupancy free of rent unless otherwise occupied. So if it's post-closing occupancy, this is just helping to clarify that. Let's see here. Are we on page 9 of 10? And there was great rejoicing. General terms. This is something that's a little different. Contract interpreted by the state laws of the state of Ohio. Any and all seller certifications, representations, or warranties covered herein shall survive the actual date of closing for a period of 1 year. Contract acceptance. Let's see. Document reflecting the final signatures of acceptance has been physically delivered to the other party is what the contract acceptance date. Contract acceptance date is not the time of the final signatures, but this is making it the delivery of the final signatures to the other party. This has been added at the end. It used to be a little bit earlier on. List all persons, entities, including yourself, who own any portion of the real estate or have ownership interest, i.e. dower rights, any kind of interest in the property. And please make sure on your contracts, this is one of the most forgotten blanks, date of the final signature. Put it in there. Make sure we got it. And then unofficially added at the end, you notice there is not at the top here a page 10 or 11 of 10 or whatever. But this is where it's permission for the title company to release the numbers, the CD, HUD1, whatever it's called in the particular transaction, to you as the agent. Did we have fun? Any questions? I'm here. Any questions, I'm here. Just let me know. Otherwise, have yourself a good one. Let me know you got this.